In the unfortunate event that someone passes away, an individual is usually left to handle what is called the probate process or the estate administration based on what that deceased person did prior to death. In this video, we are going to answer those questions. What are the legal steps necessary to handle an estate matter? Greetings, my name is Patick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. Now, I have covered this subject in various angles because there are so many ways to approach it. There is the common sense approach. What do I simply do? What documents need to be handled? The legal process, what needs to be filed with the court? How do I make sure that the formalities are kept? So there are going to be various videos regarding this subject matter, and I will just take you through the different angles in which you can think about it. So here, today, I'm just going to give you the overview of how to approach the dilemma. First and foremost, as basic as it may sound, look for the will or the revocable living trust. You want to look at the legal documents where the decedent basically laid out the terms of how he or she wants the estate to be handled. The most common scenario is that the surviving spouse has that duty to make sure that all the steps are properly followed. Once you do that, you want to make sure that you get what are known as certificate of death. You want to get a lot of copies of those because you are going to need one for the attorney who is going to in turn give it to the probate court. You want to have several copies for the financial institutions. Banks usually are going to require you to have an original certificate of death. For each financial institution that the decedent actually did business in, they are going to require that certificate of death. So once you have those general parameters handled, what happens then? I would personally recommend that you hire a lawyer so that the letters of testamentary are properly filed with the court and all the formalities are followed again. You are going to have, or the attorney, going to need to notify the creditors. You, as the administrator, are not off the hook just because you hired an attorney. You actually have quite a bit of tasks to do. You are the one that's going to handle a lot of the legwork, such as opening the estate account, closing the banks, and things of that nature. These are things that the attorney cannot actually handle. He will give you the legal documents in order to do so, and then it's your duty to follow through. So, as you can tell, it's a dynamics of kind of a team, and it's kind of nice to work with an attorney that you actually get along with and you do not feel the threat of being charged for every hour because you probably will have a lot of questions. And last thing on that, you probably shouldn't be charged on an hourly basis because based on whether it's a trust or a probate matter, you're either paid the attorney is either paid by statute a certain percentage of the estate worth, and if it's a trust administration, I would encourage you to hire an attorney that would charge you on a flat fee basis so there are no surprises. That was kind of an additional tip within the tip. If you want to find out more, go ahead and visit us at assetprotectioncenter.com or call me at 714-966-2646 and we'll talk about your situation. Thank you for watching, and I'll see you next time.